Thanks for watching this video brought to you by AN Immigration Services and Consulting. Please ensure that you watch this video at high resolution for best video quality. The content in this video is prepared for reference only. Please seek professional advice about the content in this video. Please like and share this video and subscribe to our channel. Let us be part of your journey in Australia and support you throughout this journey. In this video, we will walk through the application process and the visa eligibility criteria for applying for a subclass 482 temporary skills shortage visa in the short-term stream from the 5th of April 2024. This temporary visa lets an employer sponsor you as a skilled worker to fill a position they cannot find a suitably skilled Australian to fill. The red lines in this flow chart are an answer no to the question in a decision step. Let's start. There are two steps to apply for this visa. The first step is to submit a valid visa application. If your application is not valid, your application will not be successful even if you meet all visa eligibility criteria. For any visa applications, always check whether there are any visa conditions, act-based or regulation-based restrictions that will stop you from applying for the visa. There may not be any such restriction, or the restrictions may not apply to you. However, it is the awareness of any restrictions that is important. There are very limited circumstances in which you can submit a non-internet application form. If you are authorized to submit a non-internet application form, please ensure that you follow strictly the submission requirements from the department. Most of the applicants will need to submit an internet application using Form 482V. The visa application charge is $1,455 as of the 5th of April 2024. You can either apply for this visa in or outside Australia. If you apply in Australia, you need to hold a substantive visa or a bridging A, B or C visa. A substantive visa means a visa other than a bridging visa, a criminal justice visa or an enforcement visa. In relation to your visa application for a short-term stream visa, a person needs to nominate a proposed occupation in the short-term stream. The visa application must identify the nomination. If the nomination has already been approved, the approval has not ceased. If not, in respect of the nomination, a decision has not been made. Also, the person who nominates the proposed occupation is not barred from being a sponsor. Skills assessment is mandatory if you hold a passport issued by some specified countries or special administrative region and your nominated occupation is specified in a legislative instrument unless you are exempt from this requirement. We have provided a table showing the passport issuing countries or special administrative region and the occupations which will trigger the mandatory skills assessment. If your country of citizenship is shown in the following table and you see a tick for the country and proposed occupation, you are subject to mandatory skills assessment. However, you could be exempted if you meet one of the 6 exemption criteria. The first exemption. You hold a subclass 457 or 482 visa as a primary visa holder and is employed in Australia in the nominated occupation. The second exemption. You are employed by a company operating an established business overseas in the same or similar occupation as the nominated occupation. You are nominated by a standard business sponsor who is that company or an associated entity of that company. The third exception. If your nominated occupation is a program or project administrator or a specialist manager, and you hold a relevant qualification for the nominated occupation commensurate with the qualification specified for the occupation in the Australian and New Zealand Standard Classification of Occupations, you will earn an annual salary of at least $180,000 Australian dollars. You are nominated by a standard business sponsor who has been given accredited status by the department. The remaining 3 exemptions apply to occupations listed in the previous table except for a program or project administrator or a specialist manager. The 4th exemption. You hold a relevant qualification for the nominated occupation commensurate with the qualification specified for the occupation in Australian and New Zealand Standard Classification of Occupations. Your qualification is either obtained in Australia or from a country or place not mentioned in the previous table for the nominated occupation. The 5th exemption. You have met the standards set by Trades Recognition Australia under the Offshore Skills Assessment Program for the nominated occupation. The last exemption. Your nominated occupation requires you to hold a license, registration or membership to perform the occupation, and you have been granted the license, registration or membership. If you are subject to mandatory skills assessment and you do not qualify for an exemption, you need to have your skills assessed as suitable for the occupation within 3 years before your visa application. If your skills have not been assessed, you must have made arrangement to have your skills assessed and the assessing authority has not completed the assessment. The relevant assessing authority is Trades Recognition Australia unless your nominated occupation is a program or project administrator or a specialist manager. In that case, VDASIS is the assessing authority. With Trades Recognition Australia, you need a temporary skills shortage assessment. Skills assessment for general professional occupation is required from VDASIS. If you have submitted a valid application, the department will process your visa application, assessing whether you meet all visa eligibility criteria. The second step is to check whether you satisfy all visa eligibility criteria. If you are currently an Australian, you must have complied substantially with the conditions that apply or applied to the last of any substantive visas you held, and to any subsequent bridging visa. Simply put, you need to have complied with your visa conditions. The nomination has been approved at the time of decision of your visa application. The person who nominates the proposed occupation is an approved work sponsor when the nomination was approved. The approval of the nomination has not ceased. The position is genuine. For example, if your position has been created primarily to secure your entry into a stay in Australia rather than address a temporary skill shortage, the position is not genuine. You have genuine intention to perform the occupation. It is considered a red flag if your qualifications or competences or employment background are significantly inconsistent with the nominated occupation. You have the skills, qualifications and experience to perform the task of the nominated occupation. If requested, you are required to demonstrate having the necessary skills to perform the tasks of the nominated occupation. You have not engaged in any prohibited sponsorship conduct in the last 3 years before your visa application unless the department deems it reasonable to disregard such conduct. For example, if you offer a sum of money to induce someone to nominate you for a proposed occupation for your visa application, this is a prohibited sponsorship conduct. You need to have adequate arrangement for health insurance during your intended stay in Australia. If your nominated occupation happens to be a medical practitioner, your qualification is recognized by the relevant Australian authority for registration to practice in Australia. It is not necessary that registration be held at the time of decision. An in-principle acceptance letter from the relevant medical board is sufficient. There is no adverse information about the nominator or its associates unless the department deems it reasonable to disregard such adverse information. Adverse information is any adverse information relevant in determining a person's suitability as an approved sponsor or a nominator. For example, the department may receive a tip-off about your nominator having contravened a law of the Commonwealth, a state or a territory. The discretion to disregard the adverse information depend on many factors, for example, the nature and seriousness of the adverse information. There are various public interest criteria and special return criteria that you must satisfy. In particular, the character and health requirements. You have worked in the nominated occupation or a related field for at least 2 years. Under policy, it is expected that the work experience should have been undertaken on a full-time basis in the last 5 years. This period does not need to be continuous. You are a genuine temporary entrant, intending to stay in Australia temporarily. You intend to comply with any visa conditions that the visa of this application will be subject to. Unless you are exempted from the English requirement, you have undertaken an approved English language test and achieved the required test result in a single attempt within 3 years before your visa application. You would have already provided your test result in the visa application. We have provided a link to the legislative instrument with details about the circumstances under which you are exempted from the English requirements. Unless your nominated occupation is an exempt occupation, you can only work in the nominated occupation. There is also restriction about where you can work. You can only work in a position in the nominator's business if your nominator is an overseas business sponsor. Work location restriction is more flexible if your nominator is not an overseas business sponsor. You can either work in a position in the nominator's business or that of an associated entity. Thanks for walking through the application process and the visa eligibility criteria with us. Please like and share this video and subscribe to our channel so that we can provide more content to support you.